Okay, hopefully you can all see that.
Yeah, we can.
Now, I've got a 30-minute time slot and lots to get through, so I'm not going to talk about myself very much because that's really, really boring, except to say that I once was a biomedical engineer like many of you, and then I became a patent attorney about 20 years ago, and it's been a very interesting time. I've learned a lot, things have changed a lot, and I'm really happy to try and share with you some of the things that I've learned in the hope that you might too decide to file patent applications or become a patent attorney, but at least have some awareness of what intellectual property is, and in particular patents for medical technologies, which is the focus for today. Before I get into the nitty-gritty, I would like, in the spirit of reconciliation, to acknowledge the traditional owners of the land from which I am presenting today. They're the people of the Kulin Nations. I pay respect to their elders past and present and acknowledge and uphold their continuing relationship to this land. So Hydrix asked me to contribute this afternoon by giving a 30-minute overview of intellectual property, what makes it relevant to you, key items you need to know. But I will preface this talk by saying it's by no means a detailed presentation. It's a very light touch. It's really just intended to give you all an idea of what intellectual property is, how it might be protected, with a focus on patents, and how it might be used to give you a commercial advantage. And hopefully by the end, you'll have a good sense of when you might have developed something that is worth seeking some professional advice about. I will talk about briefly different types of IP because I think it's important to understand all the different varieties that are out there and not just patents, but we will focus on patents. We'll talk about what they are, the patenting process. And I'll touch on some key issues that seem to get people unstuck from time to time that relate to inventorship and ownership of patents and confidentiality agreements, how to search for patents, and some key takeaways at the end. I've got a lot of slides, so I'm going to go pretty quickly. So what is intellectual property on the whole? It's a generic term, and in the research sector, it's commonly associated with patents. It's a product or a creation of the mind or intellect, and it's an asset that can be protected under the law. And like other assets, like real assets, like property, it can be bought, sold, and licensed. And you might see me, my slides, or you might hear me refer to a protected intellectual property right as an IPR. So I like to think of the process of innovation as one that creates intellectual assets that can be used to gain a commercial advantage. And there are many different forms of protectable intellectual property that exist. Some of them are registrable and some of them are not registrable. As I said, today our focus will be on patents, which protect the way that things work and are really important for protecting inventions and innovations in the artificial heart space. But I think, understanding more broadly what intellectual property is useful. So I'll just run through the main types. In addition to these tiles, there's also plant breeders' rights, but I couldn't think of a way that could be relevant to this group, this audience, so I didn't include it in my slide. Trademarks provide a form of brand protection for names and logos that are used to differentiate one trader's goods and services from the similar goods and services sold by other traders. So think Coca-Cola and Pepsi for cola beverages, or Apple and Samsung for mobile phones. Trademarks can be registered, and in some countries, including Australia, there are also unregistered trademark rights under common law. Then over on the left, we have designs, which protect specifically the visual appearance of a product, not necessarily the way that it works, but the way that it looks. And designs can be registered. It's a registrable right. They can be registered in respect of three-dimensional features of shape and configuration, or two-dimensional features of pattern and ornamentation, so applied to the surface of a product, or they can be registered in respect of both two-dimensional and three-dimensional features of a product. If we had time today, I'd talk in a bit more detail about designs because I think they can often form an important part of an IP protection strategy for a medical device company, particularly for consumables that have got a unique appearance. So, for instance, I'm thinking about a face mask or a nasal cannula where there's been a lot of research going into, the user acceptance of the product, and that is really embodied in the way that it looks and feels. Sometimes that's good subject matter for a design registration. They're also a lot cheaper to obtain than a patent. Under designs, we have copyright, which protects the expression of ideas in different protectable works, such as books, artworks, including logos and illustrations, software, film, and sound recordings. Relevantly for this audience, words in technical manuals and code in software programs fall in the category of literary works. And it's worth keeping this in mind as you contemplate what it is that you've created. Copyright does not require registration in Australia, and works that are original works are protected automatically from the moment of creation. And the term of copyright protection is very long. It's the longest of all the IP rights, register of all of the legislated IP rights. It's 70 years after the calendar year of the author's death for most works that are protected by copyright. Normally, the owner of the copyright is the author of the copyright work, like the designer of a design, and the inventor of a patent is normally the one who's entitled to own the intellectual property right. However, ownership can and often does change hands by operation of contracts, such as employment contracts and deeds of assignment, and I'll touch on this again a bit later on. We also have trade secrets and confidential information, and these can be relied on to protect non-trivial and confidential information as long as the recipient of that information understands the confidential nature of it and that the information retains its quality of secrecy. These are rights that are not protected by the legislation in Australia. They're actually rights that arise from the law in contracts and equity. But like other forms of intellectual property, there are civil remedies that you can obtain from a court for breach of confidence, and these include an injunction, so relief from a court that means the infringer has to, the party in breach has to stop their breach, and damages and recounted profits, so a sum of money that's intended to compensate the owner of the confidential information for the breach. But reliance on confidential information is something that should be done with caution, because there's no way of making confidential information that's lost that quality because of a breach. And that can be very harmful for a business if their sole form of protection was a trade secret. So for instance, reflecting again on Coca-Cola, imagine if the formulation for Coca-Cola was published, it would be pretty catastrophic for the Coca-Cola company. So significant steps must be undertaken to safeguard the secrecy of trade secrets and confidential information, because it can be very difficult to receive a meaningful remedy from a court once the confidential information loses its quality of secrecy. Importantly, the secrecy of certain types of intellectual assets can be very important to the validity of the rights, as I'll discuss in a moment. So I think the safest position to adopt is to keep everything secret, and just remember the only forms of IP protection for which secrecy is not that important are trademarks and copyright. Secrecy is really important before we file an application for any of the other forms of registered right, patents and designs, and obviously secrecy is really important to protect trade secrets and confidential information. Also, more than one intellectual property right can be used to protect a particular product. And again, using Coca-Cola as the example, we could rely on a patent or a trade secret for the formulation of the contents of this bottle here, the actual Coca-Cola itself, or the process of manufacturing the Coca-Cola. We could register the shape of that Coca-Cola bottle as a registered design, and in fact, it is a registered shape trademark. And of course, the name Coca-Cola and that dynamic ribbon logo is quite a famous registered trademark. So there's a huge amount of engineering that goes into the development of a total artificial heart, from designing the flow actuation and the pumping mechanism to the materials that are used, energy and storage and transfer systems, right through to methods of manufacture and implantation. These aspects are all highly technical in nature, and they require significant resources to advance research and development, clinical testing and manufacturing. And in the research sector, a lot of grants are available to progress these concepts, but to make a real difference, as I know many of you intend to do, requires an enormous financial investment. And securing intellectual property protection for these innovations is one way of protecting that investment. So there are a lot of reasons why IP is important. For enterprises, it's important for offensive tactics, so a deterrent to stop competitors from entering into the market. If there's a third party who owns some IP that wants to sue you, maybe your patents could be used for a defensive purpose to signal a willingness to retaliate or to cross-license some IP. They also create collaboration opportunities through joint ventures and cross-licensing intellectual property so that different companies can access each other's different technologies and make advancements that way. Because patent applications are all published, they can also be used to inform competitive intelligence, so monitoring competitors to look for enforcement opportunities, to ascertain if there are infringement risks that could present a barrier to your entry into the market, and in fact helping you to navigate the IP white space, so where there's an opportunity for you to create some new IP in a particular technology area. And because patent applications are all published, even if you don't intend to pursue a patent for your own IP, you might not want a competitor to try and assert that they invented something when you knew that you had already created it. So the publication process of a patent application can be used to prior publish information over competitors. For startups, IP can be particularly important for attracting investment. So in many cases, startup founders have got little or no business experience, and they have a limited network of experienced advisors that can help them. Their business plans, if they exist, often contain no immediate revenue, but a forecast for considerable expenditure. And they may have a limited track record, both in terms of technical and entrepreneurial success. So for startups who have developed a great idea, but don't have much backing for that beyond their own know-how and perhaps a rudimentary benchtop prototype, IP can be really difficult to demonstrate. IP can be important to demonstrate the price of a funding opportunity to attract investor. Because patent rights are real property rights, a patent can be used to signal the value of an opportunity to an investment or a prospective partner. And if things go well, patents and a broader IP portfolio can be a useful vehicle to undertake a valuation of an enterprise and to contribute to its book value. And even if things don't go well, at least in the end, there's still the opportunity to sell off any IP rights that are not being commercialised and hopefully recoup some funds for the investors. IP can also be an important element of risk management for an enterprise. So if there are third-party intellectual property rights out there that could present a bar to market entry, this could put a business plan at risk. So it's important to have a good awareness of what third-party rights might be out there. And we often call that a freedom to operate study. And these are searches to identify patents, designs, trademarks, and other third-party rights that present an infringement risk. If we do identify an infringement risk, it's important for us to understand the seriousness. Is it, affecting a peripheral element of the product that we're manufacturing, or is it something that's really fundamental that we seriously need to address? And what are the likelihood and consequences of the third party enforcing their rights against us? And there are things that can be done to mitigate those risks. So redesigning the product to work around the patent, for instance. In some cases, you might be able to in-license the patented technology. And for larger corporations, they're often known to acquire the IP, so purchase the patents, or in some cases, purchase the company that owns the patents. So I mentioned all of these different types of intellectual property exist, some of which are registrable and some of which are not. Now I'm going to focus a little bit on patents. So what is a patent? It's a monopoly right. It's granted in Australia by the Commonwealth Government in exchange for disclosing the invention to the public. And that's a really important element of understanding why patents work. The patent specification provides a detailed explanation that's like an instruction manual for how to perform the invention. The patentee gets a monopoly for up to 20 years to perform that invention. And at the conclusion of that monopoly, the public can use the patent specification to go and exploit that technology themselves. But during the patent term, the patentee has the exclusive right to exploit the invention and to authorize others to do so. Patents are granted on a country-by-country basis, so there are some regional rights that exist and regional patents in, for instance, Europe, but there's no such thing as a global patent. They do need to be granted on a country-by-country or a region-by-region basis. The standard term for a patent is up to 20 years, and I have an asterisk there because the United States Patent Office likes to do things differently. They do have what's called a patent term extension that can be given to applicants where the Patent Office has caused an undue delay in the granting of their patent during examination. And I have seen some patent term extensions in excess of 1,000 days that can be very meaningful, particularly in MedTech, where often the maximum royalties are sort of generated toward the end of the patent term. That can be a really useful factor. It's also important to keep in mind if you're looking to undertake a freedom to operate study and understand the risk around, when a patent expires. Exploiting the invention, I'll just go back there, includes sale, hire, manufacture or importation of a patented product or use of a patented process, or sale, hire, manufacture or importation of a product made by a patented process. So we sometimes have process patents. A product made by a process patent in another country would be infringed by importation of that product. And an offer to do any of the above would be exploiting the invention. Patent rights are infringed by anyone who makes, sells, uses, or uses a patented product without the consent of the patent owner. So anyone who exploits the patent without the patentee's authority. And this is determined by a court who investigates if the alleged infringing product contains all of the essential features, and these essential features are defined in words in the patent specification that can be found in the patent claims. And these are numbered paragraphs that appear at the end of the patent specification. It's important that I just explain briefly the difference between a patent application and a granted patent. Only a granted patent can be asserted or enforced against someone who is allegedly infringing. A patent application is not enforceable. It is an application that's still undergoing the examination process. Products that fall within the scope of that patent application may be marked patent pending, but as I said, the rights can't be enforced in a particular country until a patent has been granted in that country. But once granted, infringing conduct that dates back to the publication date of the patent application can be pursued. So the court won't award a remedy only in respect of infringements that happened after the patent was granted, but they can allow for infringements dating back to the publication date of the patent specification. So I'm circling back here to inventorship and ownership, which is important for people to understand. Inventorship relates to the individuals, the humans who are responsible for the creation of the invention and without whom the invention would not have existed. They must be named in a non-provisional patent application. And failing to name an inventor can, in many countries, be grounds for invalidating a patent. The inventors are the ones who are entitled under the legislation to a grant of a patent. But in many cases, they are obligated to assign their rights, for instance, to their employer if they're employed for the purpose of inventing particular products. Once the inventors have assigned their rights in the patent or the patent application, as they often do, that's it for them. They no longer enjoy any of the rights of the patent. And the owner enjoys all of the rights and benefits provided by the patent. The owner may have derived their rights as the employer of the inventors or as the assignee from the inventors if the inventors have signed an assignment document. Risks to the validity of the patent can arise where inventorship is unclear. So, for instance, if there is a team of individuals that contributed to a particular product invention and one of them was left off the application documents and there's a falling out, they may later challenge the ownership rights of the person who's pursuing the patent or who's trying to bring an infringement claim if the patent gets granted. And medical innovation is often interdisciplinary, where partnerships and collaborations are quite commonplace, and these tend to have a higher risk profile for these very reasons. To mitigate those risks, it's really important that there's good documentation of all of the transmission of ownership. So make sure that you check, execute, and record at the Patent Office any relevant contract that relate to the chain of title of the invention, so the chain of ownership right from the inventors to the enterprise that ultimately wants to own the patent. So what is patentable? Devices, products, and apparatus on the one hand, and processes, methods, and systems are typically the categories of subject matter that are eligible for patents. What is not patentable? Discoveries such as laws of nature, physics relationships, the way that cellular mechanisms work, but the application of those discoveries may be patentable. Abstract ideas are not patentable. Schemes and plans, for instance, rules for playing a game, are not patentable, and formulae such as mathematical formulae. In addition to that, there are some specific exclusions that apply in some countries. So in Australia, human beings and biological processes for their generation are not patentable, and methods of medical treatment, diagnosis, and therapy are not patentable in a large number of countries, including Europe, New Zealand, and China, and I'll come back to that a bit later on. And there are also some specific exclusions against computer programs as such in a number of countries, but often we can work around that with some clever patent claim drafting. So what happens when we file a patent application? It is examined, and the examiner will look for a number of things. They'll look to see that the subject matter is patentable. It's the type of thing that is entitled to patent protection. And if it overcomes that first hurdle, the examiner will check to see if the invention is novel. So is it new when compared with the prior art base? And that is any information that was in the public domain before the priority date of the application. And I'll come back to the priority date in a moment. The prior art base includes all information, including non-confidential disclosures by the applicant or the inventor of the application that's being examined. So for this reason, it's really important to keep your invention confidential before you file a patent application so that you don't inadvertently put information of your own into the prior art base that then can be counted against you when your application is examined for novelty. And then the examiner will look for inventive step. So the examiner will try and ascertain if the invention was obvious when compared with the prior art base. There may be differences which mean that the invention is novel, but if those differences are obvious differences, then you may not succeed in overcoming the inventive step threshold test. And of course, the invention needs to be useful, which I don't think any application in the artificial heart space would have difficulty demonstrating. So the patenting process is relatively complicated, also quite expensive. The first step really is to understand when you have an invention and then consider whether you should file a patent application at all, or if it's better to rely on some other form of protection, such as a trade secret. Situations where I would consider a trade secret are where a 20-year term is too short. So like the formulation of Coca-Cola, a 20-year term might not be long enough if they can absolutely ensure the secrecy of that formulation. If you don't want the contents of the application to be published, if you've got concerns that the subject matter might not be eligible for patent protection and you failed that first sort of subject matter eligibility test for the patent, or if the invention is a fast-moving technology and a first mover advantage combined with continual updates provides a better competitive advantage than a patent, which might be outdated shortly after the application's been drafted. Most patent applicants begin with a provisional patent application, and this is an application that describes the invention and its variations and typically includes drawings. We also include claims as a best practice approach when we're drafting patent specifications at Phillips Ormonde Fitzpatrick, because the claims, as I said, are the part of the specification that the court looks to determine infringement. They form like a skeleton for the document, and the rest of the specification can be drafted around that. There is no examination of a provisional patent application. It lapses after 12 months. It's simply filed to establish a priority date and to give the applicant a little bit of flexibility in deciding where they want to file, what they need to test, if they need to go and disclose it to people. Once that provisional application's been filed and the priority date has been established by the filing of that first application, the patentee or the applicant can go and disclose the invention confidentially or publicly without risk of that disclosure invalidating their patent. The provisional application will never itself mature into enforceable rights, though. A non-provisional application that claims priority back to the provisional application must be filed. One advantage of filing an Australian provisional patent application is that an international type search can be requested, and this is a search conducted by IP Australia that can be a useful indicator as to the likely scope of claims that you might get granted eventually, and that can be quite a useful thing to have at a relatively low cost. So within that 12-month period established by the provisional patent application, it is necessary to make a decision about whether or not to go ahead. And the 12-month period, if you disclose the application or the invention after the provisional application is filed, dictates a schedule of when you need to file a bunch of future applications. Most applicants file a PCT application under the Patent Cooperation Treaty within 12 months of filing their provisional patent application. And this is an application that's filed at a single receiving office. So typically for Australian applicants, it's IP Australia as the receiving office and can be deemed to have been filed in various other countries. So there are 156 participating countries in the Patent Cooperation Treaty. And that filing of a PCT application really signals to all those countries that you're intending to file in those countries without actually having to incur the cost and all the activities involved with nationalising in those countries. The PCT application is published 18 months from the earliest priority date. So if you file one provisional application, it will be 18 months from the provisional patent application, and that will put all of the contents of your patent specification into the public domain. It will be searchable and accessible over the internet. So if you decide you do not wish to go ahead with your patent application, it's important to withdraw your PCT application before preparation for publication has been completed by the World Intellectual Property Organization, which is responsible for publication. And then Within 2.5 years of the provisional patent application filing date, so 30 or 31 months from the priority date, the PCT application has to enter what we call the national phase, or it has to be nationalised in all of the countries where the applicant wishes to have a patent granted to them. I talked about publication. This slide just shows what is published on the front page of a publication under the PCT. We've got patent classification numbers here, the applicant name here, inventors, a title. They also publish an abstract. The whole patent specification is published, and this is an example of a page of claims from that particular patent publication. So after we nationalise the application, the applications will be examined in each of those countries separately. So we can actually file a national application straight after a provisional application. We don't need to file a PCT. In fact, the national applications can be the first application we file, but this path down the left here is what most applicants in Australia would typically do. If we wanted to have patents granted in Australia, New Zealand, the US, Japan, and Canada, we need to file separately in each of those countries. We can file a European regional patent application if we want to file in the UK, Germany, Italy, and France, for instance. So the examiner in each of those jurisdictions will assess whether the specification meets the patentability requirements under the law of those countries. And during that process, the applicant will have an opportunity to negotiate with the examiner, argue on paper and amend the specification, including the claims, in order to overcome any objections that have been raised so that the application hopefully becomes acceptable to the examiner and then allowed for grant. This slide just indicates the cost, and really it's not to get too granular, but just to indicate that, you know, after the 36-month date, when we start getting into national examination, there's really a pretty steep increase that's quite ongoing in order to maintain those applications and get them through examination. A lot of countries also require payment of annual maintenance fees, either during the application process or after grant, which can also add to the cost. So where and when should we file a patent application? After conceiving a technical idea, and when you have proof of reduction to practice. So when you can provide at least one example of how to perform the invention in the patent specification. Ideally, when you've perceived some commercial value, so you can tell a story about why it's important that the invention is used. But obviously, as I mentioned before, any publication or non-confidential disclosure of the invention, including by the patent applicants and inventors. And the application should ultimately go ahead in the primary markets where you're likely to make, use, or sell that product. There are some specific issues for medical technologies. So while the fundamental characteristics of the patent system do generally apply equally across all technologies, there are some notable exceptions that I alluded to earlier. And one is the patentable subject matter exclusion for methods of medical treatment. And I've got here an example of the text from the European Patent Convention at Article 53, which says that European patents shall not be granted in respect of methods for treatment of the human or animal body by surgery or therapy, and diagnostic methods practiced on the human or animal body. And a similar exclusion applies in most countries. Notable exceptions are Australia and the United States. Methods of medical treatment, diagnosis, and therapy are allowed in Australia and the United States. The reason for this exclusion is really about a public interest basis. It's so that medical practitioners don't feel that they need to limit how they treat patients because of a fear of being sued for patent infringement. Where does this exclusion become problematic? If you've invented a new device, it's not really a big deal. But if you've come up with a new therapeutic effect that can be achieved using a known product in a new way, then it can be difficult to get effective patent protection. And similarly, if the invention resides in the processing of data that's collected from a known device. So for an example, if you had a new method of using ultrasound, a known ultrasound machine to treat cardiac stenosis, the method would be excluded from patentable subject matter under this European article. The device is known already, and so it would fail the novelty test. So we need some clever patent drafting to define a novel apparatus, so a new apparatus that satisfies the novelty and the inventive step test and doesn't fall foul of the medical method exclusion here. I had to include this slide because I really like vanilla ice, showing my age. A patentee does not normally rock up to the patent office and present his prototype to the examiner. They're more likely to do that to a patent attorney, but patent examiners and patent attorneys often undertake patent searching, and I think that this can be something that can be really useful for a number of reasons. Patents are highly indexed, so when I showed that bibliographic data slide for the patent publication, all of that information is indexed and can be searched separately. And patent searching can be done to identify patentability risks, competitors and infringers, potential partners and distribution channels, IP threats. It can be used to identify how others have solved a technical problem. So if you're having trouble overcoming a technical hurdle, sometimes the patent literature can help guide you in a way to overcome that problem. They can also be used to track movement of key inventors and to inform patent and business strategies. There is no substitute for engaging a professional searcher to do a patent search if you're serious about risk mitigation. And I'm not a patent searcher, I'm a bit of a tire kicker. We have a patent searching company that's affiliated with us. And some of our clients spend hundreds of thousands of dollars a year just doing patent searching to understand the IP landscape that they're operating in. However, many of our clients like you might not have those resources and might need to do some early stage investigation themselves. And so I've just put in the next few slides some tips and links to patent searching databases that you might find useful. To undertake effective patent searching, it's really important to know the purpose of your search. So for example, are you hoping to ascertain if your invention is patentable? Is it novel? A novelty search would look at any prior art information that is publicly available and published in any country before your own priority date, which is quite different to an infringement or a clearance search, which would be focused specifically on the countries where you wish to exploit your invention and looks only for pending applications and granted patents. And that's because a lapsed patent application or an expired patent no longer prevents an infringement risk. So understanding the purpose of your search is really important to understand the scope of your search strategy. Obviously, you need to understand the invention so that a logical search statement can be structured to cover the main concept and then secondary concepts. And typically, a search seeks to find disclosures of equivalent function rather than specific functional features, since the functional search gives a broader result, but sometimes you might need to come down to specific language that talks about specific structural features. And once the concepts are known, it's important to look at synonyms and different spellings, such as tire with a Y in Australia versus tire with an I in the United States, to ensure that relevant records aren't accidentally missed. And sometimes you might want to look for specific names, such as owner or inventor names. And this too can be built into a search strategy. Obviously, if you're doing a novelty search, you might look at non-patent literature today as well, but today I'm talking specifically about searching the patent literature. This slide on the left presents bibliographic data that's published with a patent specification. I ran through some of these items before, but I've also included here the abstract. And if a searcher is doing a keyword search, the keywords in the abstract, the title and the claims, and in some cases, the full patent specification can be searched. A patent keyword search is a type of patent search that helps you to locate patents that are similar to your invention by looking up keywords in various patent databases. And the way these work really varies from database to database. So it's important to get to know the database search features that you have access to and make sure that you're getting the results that you should be seeing. Boolean operators are really useful. Some of the search engines have field combinations that really kind of take care of the Boolean operators for you. Some of them allow adjacent or proximity operators, and obviously there are truncations and wildcards that can be incorporated, but it's worth just spending some time getting to know the search engine and the database so that you can use these features. This slide has got some free patent searching databases that can be accessed by anyone online. There are subscriber databases available as well, but they can be very, very expensive. I use the free ones. In my tire kicking searches. The first three are in bold because they're what I call primary resources. So the United States Patent Office, the European Patent Office maintains this eSpace database, which isn't just European records, but it's got patent records of many, many different patent offices around the world. And then, of course, the World Intellectual Property Organization, which is responsible for administering the Patent Cooperation Treaty, so the PCT system that I spoke about earlier. And then there's Google Patents, which is useful if you know the patent number that you're wanting to read. You can just put that in there and easily download a PDF of the granted or published specification. The Lens, which is kind of useful for analytics, and Free Patents Online, which some people use. I don't really use that one. This slide is an example of the WIPO search database and the field combination tool that's available. Here I've searched the claims for a patient interface, but I've included synonyms for patient such as subject or person, and synonyms for interface such as mask or nasal cannula. And you can see this search has resulted in more than 2 million results. If I add other features such as applicant name, because I only want to find applications and patents that are in the name of Fisher & Paykel Healthcare, and I don't want to get a separate record for every single patent in a patent family, I can limit by single family member, and that brings me down to 448 records, which is a much more manageable set of results. In a different free database, the Lens, which was on that slide, I conducted a search for artificial heart using no filters. And in the analytics section, I found this visualization of the patent owners with the highest number of patents in the data set that was retrieved. The analysis section of Patent Lens also shows a number of other things like top inventors and top cited patents. So there's a lot that can be done with patent searching, and this is really just scratching the surface in the time that we have. So key takeaways. Firstly, intellectual property is more than just patents. It's worth keeping an eye on designs and copyright, particularly in medical technologies, as well as confidential information and managing that, and maybe further down the track looking at trademarks and other forms of IP. It's important to plan an IP strategy. It doesn't happen without a bit of forethought and planning. Understand the patentability of your invention and understand the competitor landscape. Really important to file a patent application before you disclose your invention or have any non-confidential disclosure of it. And if you need to disclose it to people before you file your patent application, use confidentiality agreements or non-disclosure agreements to hopefully prevent disclosure of your invention before filing a patent application. As I said, it's not ideal because if there's a breach and you can't make something confidential that's no longer confidential, but at least it puts the recipient of your information on notice that it is confidential. Nothing happens without resources. I'm not talking about just money. I'm talking about time and effort as well. If you're serious about intellectual property, it's worth putting it in the calendar, checking in once a month on what your competitors are up to, checking in once a month on what innovations you've been working on and whether or not they might be protectable. Filing and forgetting is wasting money. It's really important that an IP strategy is aligned with a commercial pathway so that the IP can support what the business objectives are. And if you're not sure, go and see the experts, get some help, and come and see us if you'd like. That's it from me.